The use of race in a public university's admission process is once again under Supreme Court scrutiny. That's because a white woman says the University of Texas discriminated against her when it didn't offer her a spot in 2008. Texas admits the top 10% of graduating seniors across the state and fills remaining spots with what it calls a holistic process, considering race as part of the application. Joshua Tang, a senior, supports that program.
The broader question at stake in the Fisher case is whether or not we will continue to uphold equal opportunity in gaining access to higher education.
He thinks the university should have the power to admit a qualified student body that reflects the state's population. For example, Texas is 38% Hispanic and 12% black, whereas the university's undergrad population is about 20% Hispanic and 5% black. John Horton, a student and president of the Young Conservatives, thinks affirmative action promotes discrimination.
When we were arguing for the much-needed civil rights legislation in the 60s, equal protection under the law meant equal protection for all skin colors. And right now, unfortunately, with the way affirmative action is set up, it bases it on the color of your skin.
Colleges across the country are watching the decision closely.
Colleges nationally are very concerned about diversity in their student bodies, and they're very worried about any attempt to limit the way they can consider race in admissions.
As are opponents of affirmative action.
Well, the basic issue in the case is whether it is lawful for a university, in this case a public university, to discriminate.
A decision for the plaintiff could do away with the concept of racial preferences at public universities altogether. John Moan, Associated Press, Dallas.